Hi, I'm Greg Dell, and today I'm here with attorney Alex Palamara. How are you, Alex?
Great.
And today we're going to talk about what is the period of time that a employee or a disability insurance claimant has to file an ERISA lawsuit if your disability benefits have been denied. Now, in order to answer that question, Alex, I know that you recently did some research to find one of the most recent cases to discuss this issue. So can you tell us a little bit about that case and what someone should know about when they need to file a lawsuit if their benefits have been denied?
Certainly. Most long-term disability insurance policies contain contractual language that limits the amount of time that someone can bring a disability insurance claim. But the problem with this language is kind of vague. It says 3 years to bring this lawsuit, but it doesn't say when that time clock starts ticking. So a lot of people assume that the time period does not begin until the final denial. So you go through your administrative remedies and file all your administrative appeals at the 3 years after that date. And there's never any reason to wait 3 years to file such a lawsuit. But for some reason, we find that people either forget about it, move on to Social Security, and just forget about their long-term disability claim. And then sometimes it's too late to file this lawsuit. I recently came across a case that was just issued out of the Western District of North Carolina called Deborah Hyatt versus Prudential. Now, this claimant we did not represent her, not a client of ours, but unfortunately for this claimant, she ended up losing this lawsuit, ended up being dismissed because she waited too long to file this lawsuit.
So how long did she wait?
Well, she waited basically 3 years and 1 week from the final denial. But even if she would have filed it months earlier, she would have lost the case anyways. And what happened in this case, what the judge ruled was that there was a 3-year contractual limitation in this policy to bring the claim, but the claim had to be brought within 3 years in which the policy required proof of loss. And what that means is that each policy gives a certain amount of time to give the notice to the insurance carrier that you have a claim for disability benefits, and gives a certain amount of time that you have to provide them with proof of loss, meaning medical documentation, attending physician statements, and whatnot. Now, proof of loss typically has to be submitted within 90 days of the end of the elimination period, and commonly the elimination periods are 180 days. So basically, in this case in particular, she had 270 days to bring proof of loss, and then 3 years from that 270 days to bring this lawsuit. Now, she waited approximately, I'd have to assume, 90 days beyond this time limit, and her claim was dismissed by the court. But what's interesting about this, what people have to note is that the contractual time limit can be running during the time or you're doing the administrative remedies in your case. It seems unfair because you can't bring a lawsuit yet, even though the clock has already started to tick in. It doesn't seem fair, it doesn't seem logical, but that's the way the courts have seen it, especially in this recent case.
Right, so the important thing for people watching this video is don't think, I applied for benefits a year ago, I've been battling back and forth with them for a year and a half, now they finally denied me, and now I'm going to wait another 3 years because the policy says 3 years to bring a lawsuit. Because if you do that, you're never going to be able to bring your lawsuit.
Correct.
So what I know you and I always recommend is as soon as your claim is denied, call a lawyer if you're not already working with a lawyer beforehand to help you with the appeal. And you got to consider right then and there, are we going to file a lawsuit immediately or do we have a little bit of time? Because if you don't bring the lawsuit, you're done.
You lose all your rights. You should contact an attorney as soon as possible if you're not already hired by one, because there's never a reason to drag your feet. If you don't file that lawsuit in an amount of time, you can never bring this lawsuit. I get calls all the time, people saying I was denied in 2007, 2005. There's nothing I can do for you. I wish there was something that we could do, but the courts will dismiss the case.
I guess the only exception, and there really is very few exceptions, if someone had legal incapacity, then maybe they make an exception, but it's so unbelievably rare that it almost never happens.
It's tough to prove.
So if your claim has been denied, you need to file a lawsuit, or your claim has been denied, you need to file an appeal. Feel free to give us a call at any time. We always offer a free consultation, and we look forward to the opportunity to speak with you.